We are going to reconsider the report of the Portfolio Committee on the donation of high-value species to certain individuals in the Northwest Province. Honorable member will remember that we finalized this report last year already. We submitted it to the House. It was 80 seat, and it lapsed last year. This year it was revived, and in the process of being revived, it was returned back to the committee. And I will explain why it was returned back to the committee. The second issue that we'll deal with is the bill that we are supposed to be processing, the NEMLA bill, National Environmental Management Laws Amendment Bill. So we have confirmation of about 3 stakeholders who are going to be making inputs on the bill today, and tomorrow there is another list of stakeholders who have confirmed. I'm told that others are not able to come, so we will decide how then to treat those other stakeholders who have made written submissions but are not able to come here. It does look like we haven't received a lot of inputs as we have anticipated. But nevertheless, we'll have to process those that we have received so that we can be able to finalize this bill as soon as possible. So yeah, it's today and tomorrow we are going to have the public hearings on the bill. Now, the issue of donation of high-value species by the Department of Rural Environment and Agricultural Development in the Northwest. The report that has been 80 seat approved by the committee has been distributed to the members. Now, let me just explain what happened. After the committee approved this report, we send it for approval by the House because some of the recommendations that are here require the House approval. It lapsed and then it was revived this year. And in the process of revision, we got advice from the leadership of Parliament that it will be more appropriate if we include the involvement of the NCOP in the implementation of the recommendation, particularly those recommendations that will require that we must follow up and we must monitor their implementation as Parliament. Because the NCOP deals directly with the provinces, the advice is that we needed to include a recommendation in the report that make sure that it includes the NCOP in the process of monitoring the implementation of the resolution. So I spoke to the chair of the Select Committee in the NCOP, Select Committee on Land and Mineral Resources, Honorable Sifako, and we agreed that we were going to have a joint sitting of the Portfolio Committee on Environmental Affairs as well as the Select Committee in the National Assembly. We were supposed to have a joint sitting today. So it was agreed to. But then this morning we got feedback that we can go ahead and finalize it and include that recommendation in the report. And later on we can then communicate to the chairperson of the NCOP what our recommendations are and what will be the involvement of the NCOP. So basically they are saying we can proceed and include that. They've got no objection to that, and we can just communicate with them. So it's just as simple. That's why we've given it about an hour between ourselves and the NCOP, because we think that the main content and body of the report still remains intact. What we needed to do was just NCOP involvement. Now I know that there's been some reporting. I was listening to the radio this morning. The commentary which seeks to which generally confuses this report with the current developments around donation. Some donation that was made, which was reported over the weekend. Now ours is a process which we started, I think, in October in 2016. Yeah, in October 2016, when we picked up that there was a donation of this high value species, the buffaloes, the nyalas, and all the other animals which were donated by the department to some private individuals. So we then initiated that process of trying to find out exactly what was the issue. Remember, members, we sought a report from the portfolio committee in the legislature. We did not get that report, and then we invited the MEC. We had 2 sessions with the MEC. Initially, there was a bit of reluctance, but ultimately she came together with the team. We went through all the issues. They made a presentation. And subsequent to that, after those 2 engagements, we then had a discussion with the scientists. We invited the scientists here, and they gave us their presentation. We interacted with it. We then invited them to make a written submission, confirm in writing what they were told us. They did that, and then later on, we then dealt with our report. It took time because of the nature of the report as it is to finalize. So we've finalized, we've got our observation, we've got our recommendations as the portfolio committee. So basically, at the crux of what we are recommending to be adopted by the House is that the whole transaction has to be reversed, because the donation was not done in line with the requirements of the PFMA, and therefore we want Parliament to direct the department and the relevant authorities there to reverse this donation with immediate effect. And we are also recommending that because there is prima facie evidence of the anomalies that took place and the possible violation of the PFMA, the Auditor General and the National Treasury must take the necessary step to investigate this donation for possible financial irregularities, which investigation may result in a finding that the cost of the reversal must be recovered from the persons involved, which is the MEC or the accounting office, or both, and the relevant entity that might have been involved. And we are also requesting the AG and National Treasury to report back to us within the next 3 months. And we're also recommending that the department must finalize the game donation policy that we were briefed by the DDG here, Shoni, that there is a draft game donation policy that has been considered by the department. We said that it must be finalized in the next 3 months. And we're also saying that the legal services must give us an opinion within the next 30 days on the steps that must be taken against individuals, because there is evidence that the committee was misled regarding the donation, especially in relation to the game donation policy, because we were told that it was done in relation to the valid game donation policy, and it later transpired that there was no such a policy. And then we're saying that the committee must seek further guidance in terms of referring this matter to the relevant law enforcement authorities. So basically that was our recommendation, and what we are seeking now today from this committee is to include the involvement of the NCOP as one of the houses of parliament that is also tasked with dealing with issues that relates to the provinces. So I'm going to open up to members to get the views and opinions. I'm not expecting this discussion to be long. You don't have to regurgitate what is there in the report or what we discussed before. So the report is open. You are welcome, Honorable Khadel. I see you attempted to raise your hand as you are walking in. But okay, Honorable Peden, Honorable Liang, and then Honorable Makubela will be the last.
Thank you, Chair. Chair, this has dragged on a while, and obviously we all want finality on this, but if you could just give us clarity on the role the NCOP is going to play in this process. I'm not quite sure on that. This report goes there, do they stamp it? Can they change it? Do they implement it? Could you just explain to us the role that they play and the timing on that?
Well, our discussion is that we must include the role of NCOP in the monitoring of the implementation of the resolutions that are in the report. So that involves following up on the extent to which they are implementing, requesting reports, the NCOP together with ourselves. So we'll still be involved, because some of the issues that we are recommending here, the AG, National Treasury, reporting back in 30 days, they will report to us. But in as far as the actual reversal of the transaction as we are directing, the NCOP will have to be involved in making sure that we make follow-ups and that the relevant authorities, they implement this. So from where I'm sitting, I think it's a measure to make sure that everything else is tightened up. We don't leave anything out to chance. So the NCOP will not have changed the recommendations or the report, because they've not processed the issue. It was processed by us, and it belongs to us. Honorable Liang.
Yeah, no, thanks, Chairperson. Seemingly, Chair, here you have a dilly-dallying approach by the department to implement the resolution. By the look of things, it's not that they are in the dark, that someone did actually go wayward in terms of the policy, because they make references to old game policy, and on the other side, they try to justify their action, of which you can see that actually something went wrong here. So over and above the involvement of the NCOP, I would suggest, Chairperson, that we go out of our own way as a portfolio committee and make an in-loco inspection. We see ourselves as to where these animals are and the conditions that they are in now, considering the fact that it has long been agreed by the committee that certain actions be taken, or the reversal of that must be undertaken by the department. But seemingly there is no cooperation around that. So that is my suggestion, Chair, and also to look at other options to take with the authorities governing the management of animals in that arrangement, because there might be criminal elements involved in this whole exercise. Thank you, sir.
Okay, thank you very much. Honorable Makubela.
No, Chair. The input by Honorable Dr. Luyenge just make me think that probably we may be reversing something that is not there. But I don't think that's what he's saying. So, yes, I will agree with his proposal that perhaps we need to know whether what we're reversing does exist or not. But Chair, what I wanted to say is, for me, the guidance or advice by parliamentary leadership on our omission of inclusion of the NSOP is in order. So all we need to do now that we have included their role there, as Parliament involves the two houses, and they in particular deal with provinces, we must just pass it as is, and then cause them to partake in whatever role in the implementation of our recommendations. Thanks.
Okay, any objection? So we agree that we will include the NCOP role in as far as monitoring of the implementation of the resolution. And we also include Dr. Luyenge's proposal that there must be some in-loco inspection or oversight visit to satisfy ourselves that that reversal takes place. Okay, so we will include those two recommendations in the report, and then we will make sure that the report gets 80 seat. Our intention is to debate this report and approve it sometime this week, latest next week. This week we are left with tomorrow and Thursday. I don't know when is the sitting on Thursday? Okay, so we might have to debate and approve this report next week in the House, because it's long overdue. I agree with Honorable Peden. It's a long overdue report. I mean, since October 2016, and I'm sure a lot has since transpired with these animals. So we must make sure that we approve the report, and then we make follow-ups, because it's a lot of animals that we're talking about here. worth over 100 million rand. And that is a very conservative estimate. It might even be more than that when you look at the fact that it's high value species, buffaloes, sable antelopes, and all these animals. So we will then try and target next week Tuesday, because that report must be, as we have approved it again now, we must ATC it, and then it must then be referred to the House. Okay, we are done with this one. Honorable Whip.
Saying, Chair, it won't be next week Tuesday because it's a
Oh.
holiday.
Okay,
Yeah. Okay.
next week Tuesday it's a holiday, so it might be sometime next week. There is a possible traveling next week by myself, but I'm sure honorable members are quite clued up with the contents of the report. They can even discuss in my absence, even if I'm not there next week. But we are targeting next week. If it doesn't happen, we'll do it that other week. But it's very urgent, this report. A lot of irregularities has happened, as you know, honorable members, a lot of wrong things. Basically, a serious flouting of the law and legislation. It's as if somebody was running his or her own personal fiefdom. No rules applying, nothing. Just do as one's wishes with the resources of the people of this country, the people of Northwest. So we said we are not going to allow it. Can we move to the next one, which is the bill? We will then, can I check if all our stakeholders are here? We are supposed to start with the Western Cape Provincial Government. Can I check if Mrs. Rousseau is here? Okay, she's here. City of Ekurhuleni, Mr. Eskrin. Okay, thank you. And the Banking Association of South Africa, Mr. Venter. Is Mr. Venter here? Okay. So we are hoping that Mr. Venter is going to join us. But let's give to the department, then to briefly, I'm sure the details of the bill has been, people are aware of what the bill is all about, but I think as procedure, we must just get a presentation and then deal with the bill. I must say that I'm going to ask to be excused at about 11, just to attend to a matter that I can't postpone, but the whip, I'm sure, can steer the ship in my absence. Sham, are you going to make a presentation?
Good morning, Chair, honorable members. Unfortunately not, Chair. I'm going to delegate that function to Mr. Shabalala, who's and Ms. Gallup, who are leading the law reform process in the department. We've also got the respective experts from the various line functions that have requested amendments on the bill, Chair, to talk to specific issues around why they're requesting those amendments if necessary. So I'd request, Chair, that we be allowed to ask Mr. Shabalala to present the bill. We've got the respective DGs from the line functions. Mr. Mark Gordon, Chair.
No, I'm saying not from DIA. You say they are...
No, it's our line function experts, Chair, our
only
DDGs within the department.
Oh,
yes, Chair.
okay.
Yeah. Okay.
I thought there are officials from other departments, not from DIA, who are asking us to look at amendments
No,
that
no,
they
no,
want
Chair.
to suggest.
My apologies, Chair, for
Wow.
it's our internal DDGs and their line functions that
Alright.
are requesting the amendments, Chair. Okay, thanks.
Great.
Mrs.
Mr. Shabalala, are you ready? I know you can be very slow and meticulous and taking your time, but just
So today I must.
go through
Okay.
this a bit faster so that you are able to finish.
Okay. Thank you, Chair. Morning, Honorable Chair, honorable members. I'm going to present the National Environmental Management Laws Amendment Bill of B14 of 2017. Briefly, the background, the department is basically responsible for various specific Environmental Management Act, including our framework legislation, which is the National Environmental Management Act. Through its implementation, we have encountered a lot of different opinions, specifically with respect to the interpretation and the application as well as the implementation of this legislation. And this has resulted in some inconsistencies as well as challenges with respect to implementation of this legislation. So in summary, these inconsistencies that we have picked up is related to permitting processes, non-compliances with environmental legislation, as well as some governance management issues, specifically on our National Biodiversity Institute, as well as the South African National Parks and the Waste Management Bureau. As a result, this bill intends to amend the list of those legislations that we've listed there, with an overall intention of providing clarity by strengthening our integrated environmental management, the One Environment System, which came into operation on the 8th of December 2014, our compliance and enforcement measures and tools, as well as biodiversity and conservation measures, our air quality management measures, as well as waste management and our integrated coastal management issues. Briefly, under Integrated Environmental Management Act, the main amendments that we are proposing now is to provide for simultaneous submission of environmental authorizations that are related. Here we are talking about activities specifically on the environmental sector, where you have a same development requiring more than one authorization, and where the minister is actually the licensing authority. So in that instance, we are proposing that there should be a sort of a integrated license permitting that particular development or activity. And we believe that that approach will then allow us to have a one-stop, one process that will allow us to gather all the information related to decision-making for the development and the issuing of the integrated license and authorization. And that basically will also lead to, we hope that it will lead to streamlining as well as the effective implementation of our integrated environmental authorization. Under the One Environment System, we are proposing the One Environment System basically is a system where the environmental authorization related to a mining activity, that license is issued by the minister responsible for mineral resources. The environmental authorizations that are related to that particular mining activity, only the air quality activity still remains with the minister responsible for environmental affairs. So the waste management activity, if it's related to the mining activity, it will also be issued by the minister responsible for mineral resources. So this process, this amendment is necessitated by the fact that the 2014 amendment, when those amendments were made, there was also the MPRDA amendments related to the 2014 amendment. Unfortunately, that MPRDA bill is still not yet being promulgated into an act of parliament. As a result, we have picked up that there might be a gap, specifically because the trigger in terms of the One Environment System, where you have multiple authorization required for the mining activity, that trigger is in that bill, which has not yet been finalized. So this proposed amendment under NEMA, it's intended to provide that trigger, where the trigger is that where there is a mining application, which also requires maybe a waste management or an air quality activity, the Department of Mineral Resources must first accept that application of the mining right. And then after the acceptance of that mining application, then all the relevant licenses, your water, your environmental authorization must then be submitted to the relevant authority for simultaneous processing by the different department. So by this amendment, we are intending to provide for that trigger in NEMA now, because under the MPRDA, that act has not yet come into operation. So this is intended basically to make sure that there is that trigger and there's that simultaneous consideration and decision making with respect to that particular application. The second amendment under the One Environment system is to provide for the applicant as well as the holder of environmental authorizations relating to mining activities that they should, as a legal obligation, set aside financial resources that will assist in terms of progressive rehabilitation, mitigation, remediation, mine closure, as well as management of post-closure environmental impacts. We are also clarifying with this amendment to NEMA that the minister responsible for mineral resources will also be responsible for the implementation of the license system, as well as the exemption provisions insofar as it relates to a waste management activity. As I explained just now, that the minister responsible for mineral resources is also responsible for issuing a waste management license relating to a waste activity in a mining area. The amendment also under NEMA intends to deal with those environmental management programs and plans that were previously regulated under the MPRDA, because when NEMA came into operation, there were still some aspects that were lagging behind. So we're trying to, with this transition, to provide some sort of clarity that those EMPRDA must be deemed to have been approved and an environmental authorization issued under NEMA. But that doesn't cover any illegal activities that, for example, an activity that was not licensed in terms of the law before. So this only covers the ones that were legally regulated under the law. It's also to provide clarity that all the environmental appeals, because before the Department of Mineral Resources was responsible for all appeals, including environmental appeals relating to a mining activity that were issued under the MPRDA. So we're just providing clarity that those appeals, specifically environmental appeals that were lodged before 8 December 2014, must be finalized in terms of the MPRDA. This is important because after 8 December 2014, the Minister of Environmental Affairs is the appeal authority with respect to mining decisions relating to mining activities of environmental authorization issued under NEMA. Also, we are providing clarity that the regulations, specifically the environmental regulations that were developed under the MPRDA should continue. Specifically, these are the residue deposit and stockpile, as well as the financial provision regulations, should continue until similar regulations are developed under NEMA. Still under the One Environment system, we are providing clarity that residue deposits and stockpile, the management of those activities are now going to be under NEMA, not under the Waste Act, because currently we are providing for such management to be under the Waste Act. But due to challenges, we are now moving them to be under the framework legislation. So basically then the overall intention of this regulation is to provide for the utilization of one process for information gathering in order to inform integrated decision making and to allow for the issuing of integrated licenses and authorizations where related to the One Environment system, but also to make sure that the streamlining and strengthening of licensing processes and requirements for the One Environment system. Compliance monitoring I think this is the big part of the amendments under NEMA. The first one is Section 24G. Currently, Section 24G does not allow any successor in title or a person in control of land to lodge a Section 24G application. And we pick that one as a legal loophole that needs to be closed, so that any person that buys a land, for example, can be able to then apply for a 24G process where there might be an activity that needs to be rectified in that land. The second amendments are on Section 28. Section 28, it's a tool that is used by our environmental management inspectors, directives that are issued to people that are not complying with the environmental legislation. The first aspect of the amendment is to bring any owner of land or premise or person in control of land or premises or person who has the right to use the land under this ambit, because currently the environmental authorities are not able to issue directive specifically to those individuals. So the intention of this amendment is to make sure that those people that I've mentioned, they also have the legal requirements of duty of care, meaning that they must make sure that whatever activity that is undertaken in their land is in line with environmental legislation. So it's to close that legal loophole as well. The second amendment under Section 28 is to empower our municipalities specifically to issue Section 28 directives, because currently they don't have the power to issue those directives. So it's just to make sure that we give those municipalities the power to issue Section 28 directives. The next amendment under 28 is on subsection 4. It's to ensure that any person that is issued with a Section 28 directive, that that particular person is given a prior representation through a pre-directive process to represent his side of the story before a final Section 28 directive is issued. So this is intended to comply with the Promotion of Administrative Justice Act requirements as well. The next amendment under 28 is on 2811. This deals with the situation where the Director General or a department undertakes a particular activity which is, has financial, excuse me, financial implications where to respond to any environmental harm. The current approach does not allow the department to actually recover those costs, where the department has actually spent money to mitigate or to deal with a particular harm from the relevant person that might have caused that particular harm. So this amendment is intended to firstly to make sure that we recover those costs that we might have spent in dealing with that harm, but also to where there's more than one person, to be able to provide for joint and several liability for those responsible individuals. So it's just to make sure that we are able to recover those costs. The next amendment under compliance and enforcement, it deals with the powers of, is to deal with the powers of environmental management inspectors, as well as the environmental mineral resource inspectors, specifically where the Department of Mineral Resources have actually issued that environmental authorization. Is basically to extend the same powers that the EMIs have to those EMRIs under NEMA. The last amendment under compliance and enforcement is to ensure that the EMRIs under the Department of Mineral Resources receive the same training that is received by any environmental management inspector before they are designated to be established, to be designated as inspectors under NEMA. So these amendments are basically intended to ensure that the minister responsible for mineral resources is able to designate officials from any other organ of state in the Department of Mineral Resources, but also to ensure that there's consistency with respect to the training that both the EMIs and EMRIs receive before designation. Under compliance and enforcement, again, we are extending the powers of MEC when they designate EMIs to also ensure, to allow the EMRIs at provincial level to also be responsible for monitoring and enforcement of their own provincial legislation. That includes their ordinances as well as any provincial legislation that the province might have developed. It's also, the next amendment is also to empower the Minister of Environmental Affairs to establish the EMI Code of Conduct through regulations that will be published under NEMA. And that also to allow the templates that might be used for enforcement purposes to allow for flexibility in terms of those templates. And then these amendments are intended to strengthen the administrative as well as compliance and enforcement powers of EMIs and EMRIs. The amendments also under NEMA are also intended to empower EMIs to react to complaints and tip-off in order to verify and confirm facts, and also to turn a mere suspicion into a reasonable suspicion, and they can then take it up through the relevant processes. The amendments are also empowering the EMIs to temporarily detain a consignment for further assessment or analysis in order to establish consignment. These are basically those where you have to ensure that you keep a particular consignment for analysis and assessment before it can be deposited into a safe place. The amendment are also intended to provide EMIs with flexibility to deposit the seized live specimen with appropriate facilities depending on the circumstances, because currently the provisions are not providing that flexibility in terms of where some of these live animals can be accommodated while pending investigation. The amendments under biodiversity and conservation management, it's only 2 amendments that we are making to NIMBA. And the first one, it's related to alien listed invasive species. It's just to empower the minister to prescribe or to develop measures and methods to be undertaken with respect to listed invasive species. And this is related to our biodiversity and conservation measures. The next part, which relates to governance issue, is to allow our chief financial officers for both SANBI as well as SANPACs to be ex-official members of their respective boards. And this is to make sure that we comply with the King 3 report on good governance. Air quality management amendments is to provide the minister with a discretion to establish the National Air Quality Advisory Committee where necessary. And then the second amendment is to clarify the applicability of Section 22A. Section 22A deals with rectification. It's similar to 24G. Is to clarify the scenarios where, or the circumstances under which a person can apply for a rectification of an activity. And those 2 scenarios are, before the Air Quality Act, we had Atmospheric Pollution Prevention Act, which required a person to obtain a registration, a sort of an authorization under that act. And that act, when it was repealed by the Air Quality Act, some activities were carried over to the Air Quality Act. So the first scenario is to make sure that any person that did not have or do not have a registration certificate under APA can actually apply for a rectification of that activity. The second scenario is where a person operates an activity that requires an air quality license under the Air Quality Act to also apply in terms of Section 22A. So those are the two situations that we are trying to clarify with this amendment. The third amendment is to allow for the minister to issue an integrated environmental authorization where the Minister of Environmental Affairs is also identified as the licensing and competent authority regarding a listed activity that requires an environmental authorization, an atmospheric emission license, as well as a waste management license. So in those three situations where the minister is the licensing authority or a competent authority, then an integrated environmental authorization may be issued by the minister. Also to provide clarity that a province is to be regarded as the licensing authority where a listed activity falls within the boundaries of more than one metropolitan municipality or more than one district municipality. So that in that instance, then the relevant MEC will be the licensing authority for the air quality activity. The amendments also under Air Quality Act are to ensure that the air quality appeals follows the appeals process as implemented under Section 43 of NEMA. The waste management amendments relates to, the first one deals with the definition of waste as well as Schedule 3. We are amending Schedule 3 as well as the definition of waste as contained in Section 1 to clarify what is waste and the issues around when does waste stops to be a waste. So we're trying to provide clarity onto that by amending the Section 1 as well as Schedule 3 because there were some unintended issues in Schedule 3 that we have to move around in the different tables. The second amendment under the Waste Act is to provide for the establishment of the Waste Management Bureau as a public entity with a board of directors, and the Bureau will then be responsible for implementing the industry waste management plans and to deal with any issues pertaining to waste management plans, either as a capacity as well as to provide capacity support or to provide any relevant support. The amendments to the Bureau also sets out a number of governance issues relating to how the Board of Directors should relate to itself. I think they are listed.
Mr. Shawala, you are doing exactly what I said you should not do. Remember, you presented this thing to us. We had a 2-day workshop. The bill is out there. People have commented on the bill. I don't know what is this exercise for. I wanted you to summarize it.
Okay.
Now you are going exactly what I said you shouldn't do. Explain. You have already given this explanation to us during the workshop. So summarize it and let's get the stakeholders to present on it.
Okay.
We know what you are saying now, you have presented it, I think, twice already. So just summarize the issues and then let's get.
Okay, this is the second last slide, Chair. I think the next one is the integrated one, so it's done. So in terms of the Waste Act, also we are providing clarity under to ensure that there is a register only for contaminated land, and also that the site assessment reports must be submitted together with the remediation plan to the Minister for approval. And also we are providing clarity with respect to the instances where the MEC may be, the Minister may be the licensing authority when there's a complaint. The last slide, Chair, deals with the Integrated Coastal Management Amendment, which is to provide for the retrospective application of the removal of the removal notices for illegal structures, where it is currently only implied. So it's just to ensure that we are in line with Section 28 of NEMA. Thank you, Chair.
Okay, thank you very much. Can we go to, is there anything that members wants to raise for now? Okay. Can we get to Western Cape? Are you able to come sit here? And all other presenters will be making submissions. Can these few chairs here, 1, 2, 3, basically this row, it's meant for those who are going to present. You can switch it on.
Thank you, Honourable Chair. So my name is Annie Crusoe, and this is my colleague Paul Hardcastle, and we are just going to take you through some of the comments submitted by the Western Cape Government on the current version of the bill as is in Parliament. I just want to start off with a bit of a background and introduction. So the Western Cape Government originally submitted comments on the version of the bill published in 2015. We subsequently also engaged with our national and provincial counterparts at the relevant intergovernmental structures, which is your MinTech working groups. And I just want to confirm that the comments we submitted in writing includes 3 different sets of comments. So firstly, we made comments supporting proposed provisions included in the bill. We also made comments not supporting proposed provisions included in the bill. And then we also made proposals for additional comments which aren't contained in the bill, which we believe should be contained in the bill. The presentation I'm about to give literally just highlights some of the very key comments that we provided on the bill, but we note that our detailed written submission must please be studied. So this presentation is just a brief summary of some of the main comments we made. Just a summary of the comments that I'm going to be highlighting today. So first of all, in terms of the National Environmental Management Act, or NEMA, we want to highlight comments regarding the definition of financial provision. First off, we believe that the definition should not be limited to mining activities. And secondly, that it should make adequate provision for all impacts associated with a specific development. The second issue I want to highlight under NEMA is we strongly believe that the inclusion of latent impacts within the scope of financial provisioning must be ensured. Thirdly, that the Minister of Environmental Affairs should be afforded the opportunity or the power to act in terms of Section 31 capital D8 without requiring concurrence from the Minister of Mineral Resources. And then the last issue I'm going to raise under NEMA is regarding the identification of the competent authority for activities related to national priorities, and we believe the current system should be reconsidered in this regard. Then, in terms of the National Environmental Management Air Quality Act, or NEMAQA, the key issue we want to highlight is also regarding the licensing authority for air quality related activities related to national priorities. And again, we believe that the identification of the licensing authority should be reconsidered. And lastly, we're going to raise one key comment related to the NEMA Amendment Act of 2008. We don't support the principle that an EMPR or an EMP approved in terms of the MPRDA can be deemed to be an environmental authorization issued in terms of NEMA. We do, however, support the very critical qualification or condition accompanying this deeming provision. Okay, so first off, with regard to the definition of financial provision, first of all, the bill proposes an amendment to the first part of the definition, but not the latter part of the definition. So with regard to the first part of the definition, which is included in the bill, we propose that the definition should not be limited to mining-related development, but should create an enabling context that can be applied to all listed and specified activities, as is clearly intended by Section 24P7 of NEMA. When one looks at the memorandum of the objects accompanying the bill, it states that the definition applies to an applicant for environmental authorization, a holder of an environmental authorization, or a holder of a right or permit granted in terms of the MPRDA. Now, this rationale we support. It's however not evident in the current wording of the definition, which is a concern for us. So we believe the definition must be clarified to clearly include applicants for or holders of environmental authorizations for all listed or specified activities, as well as holders of old order mining rights. Just one example is polluting industries that will have the same environmental implications as the mining sector. We just want to make sure that these polluting industries are also included, potentially included in terms of this provision. Then the second comment we want to highlight, also relating to the definition of financial provision. So this part of the financial provision is not proposed in the bill. There's no amendment proposed to the latter part. We however believe that it's not apparent in the current definition that adequate provision is being made for post-closure impacts. For example, another example is shale gas. So what we're proposing in this regard is to expand subsection D of the current definition to include reference to monitoring and mitigation in the beginning of subsection D, as well as including the words during post-closure monitoring at the end of subsection D. In addition to this, we also believe that currently subsections A to F of the definition list certain aspects for which the availability of sufficient funds is required. One example is decommissioning and closure of operations. So we believe that paragraph E should refer to and, should end with and instead of or, which would mean that sufficient funds must be provided for to possibly undertake all the aspects listed in subparagraphs A to F and not just one. And this is also consistent with the environmental right contained in our Constitution and sets an imperative for intergenerational sustainability and ecologically sustainable development, while also supporting justifiable social and economic development. Okay, then moving on to the inclusion of latent impacts in the scope of financial provisioning. There is a provision included in the bill. The provision proposes the deletion of the word latent, which is of a concern for us. Currently, NEMA does not contain a definition for either latent or residual impacts. It's therefore not clear to us what the actual practical implication would be of deleting the word latent in this context. When one looks at the objects of the bill, there's not really clarity provided. So we believe that the legislation is not clear that latent impacts are included and must be addressed as part of financial provisioning. If the word latent is removed, then it must be clearly specified that latent impacts are included within the definition of residual impacts, which currently it's not clear for us. And this clarity is especially important when one looks at the definition of latent impact as currently included in the MPRDA regulations, which reads, any environmental impact that may result from natural events or disasters after a closure certificate has been issued. So we strongly believe that clarity is required in this regard. Then moving on to the power to act in terms of Section 31D. So again, this is not a provision that's included in the bill. We are proposing this as an additional amendment we believe should be included in the bill. Section 31 capital D429 of NEMA currently sets out detailed requirements and procedures for when the DMR officials fail to comply or fail to perform certain functions in terms of compliance monitoring and enforcement. So in terms of Section 31 capital D8, the Minister of Environmental Affairs may intervene and take certain reasonable steps, but the Minister needs concurrence from the Minister of Mineral Resources. Now, we believe from a practical perspective that this concurrence shouldn't be required. So we're proposing the deletion of requiring concurrence from the Minister of Mineral Resources before the Minister of Environmental Affairs can intervene when DMR fails to perform their functions. Then the next one, which is the last comment we want to highlight under NEMA, this provision is included in the bill to expand the scope of Section 24 capital C3 agreements, which we support, but our preferred option would in fact be an additional amendment to Section 24C. So first off, I just want to note Section 24C of NEMA identifies the relevant competent authority for applications for environmental authorization for both listed and specified activities. Generally, in terms of Section 24C, the MEC would be the competent authority unless it's an activity relating to international environmental commitment or relations, for example, renewable energy, or the activity will fall across more than one provincial boundary or transverse international boundaries. Now, Section 24C to capital B provides that the Minister must be identified as the competent authority where a Cabinet decision stipulates that the Minister must be the competent authority for activities related to a national priority. Section 24C3, however, allows the Minister and MEC to agree that certain applications for environmental authorization may be dealt with either the Minister or the MEC. Currently, Section 24C, however, does not apply to matters declared as a national priority. So there's no opportunity for the Minister or the MEC to actually reach an agreement that the MEC can, in fact, deal with a national priority. Now, this is problematic for us for the following respects. First of all, we certainly do support the principles of national priorities. However, we believe that the practical application of what is a national priority must be specific, transparent, and reasonable. There must be objective criteria developed in terms of how this is actually allocated. And there can't be just a blanket type of development should all be national priorities. Then also we feel that the notion that only national departments is competent to actually be the competent authority for activities related to national priorities is flawed. Sometimes the provincial department would in fact be a more appropriate decision maker on a specific matter, even if it is a national priority. And lastly, of course, in terms of Schedule 4 of the Constitution, we all know that the environment is a concurrent national and provincial competence. So yes, currently the bill does propose to expand the Section 24C agreement to also be applicable to national priorities, which we definitely support. However, this is not our first or preferred option. Our preferred option would in fact be to delete Section 24 capital C 2B, which is the section indicating that when something is declared as a national priority, the national minister must be the competent authority. We believe that Section 24C should be applied together with agreed criteria, and then in an appropriate situation, the MEC and the minister can reach an agreement that if it's appropriate, the minister must in fact be the competent authority. We believe this is a more appropriate and transparent mechanism to allocate national priority matters to a national minister in a specific situation, if appropriate. And this is also consistent with the principles of differentiation and subsidiarity. Okay, then moving on to the National Environmental Management Air Quality Act, or NEMAQA. Similarly to the comment I've just dealt with, this relates to a provision included in the bill to expand the scope of Section 36(8). Also a similar principle about the agreement, which we support. But again, our preferred option, or our proposed option, is an additional amendment to Section 36. So just briefly again, in terms of Section 36(5) of NEMAQA, the Minister is again identified as the licensing authority for so-called national priorities. Similar to the previous comments, Section 36(8) also provides for a possible agreement between the Minister and the licensing authority, or the MEC and the licensing authority, regarding the identification of the relevant licensing authority. Currently, the possibility of reaching agreement, however, also doesn't apply to matters declared as a national priority. And again, we have the same challenges with this as we had with the previous comment, and here even stronger as air pollution is a municipal competence. And yes, we do support the proposed expansion of this provision to now also include matters of national priority. And I just here want to stress that we're clearly showing our support in case someone challenges this provision. So we definitely support this provision to also expand the scope of possibly reaching agreement. But again, we believe that this is not the preferred solution, as it really does not adequately acknowledge the constitutional allocation of air pollution as a municipal competence, as I've mentioned. So what is our preferred option? Preferred option is to delete Section 36(5)(c) of NEMAQA, which identifies the national minister as the licensing authority for national priorities, and similar to our proposal in the previous comment, allow the district and metropolitan municipalities to be the licensing authorities, and then potentially reach an agreement with either the national department or the provincial department in a specific situation if it's more appropriate for them to in fact be the competent or the licensing authority. Then the last comment I'm going to be highlighting is, as I said, in terms of the 2008 NEMA Amendment Act. So currently this provision is included in the bill. The principle that an EMPR and EMP that was authorized or authorized in terms of the MPRDA is now deemed to be an environmental authorization issued in terms of NEMA. We do not support this deeming provision, but we do support the very important additional criteria attached to this deeming provision. So as I said, we do not support the principle. An EMPR is not an environmental authorization. They've got very different roles, they've got very different functions. There's a marked difference between the two, between an environmental authorization issued in terms of NEMA and an EMPR approved in terms of the MPRDA. The requirements for the assessment of the environmental impacts of a listed activity in terms of NEMA are far more stringent than the requirements which are provided for in terms of the MPRDA. There was also a recent Western Cape Government High Court decision.
So can you explain the differences between the two?
Okay. I'm just going to, this is my last slide. I'm going to just go through the last slide, which goes into a bit more detail. And
Okay.
if still, then we'll explain a bit further. So there was also a High Court case, Mineral Sands, which specifically, amongst other things, looked at the relationship between environmental impact assessment and environmental management program. I'm going to read this quite lengthy part of the judgment, which might, and then summarize it a bit, which might answer your question. So the court held that there must
Which
be...
court was that, by the way?
It was the Western Cape High Court. The full reference is in our written comments. Mineral Sands Resources case.
Okay.
Proper appreciation of the function of an ENP and of the reason for the more rigorous process required for environmental authorizations. In terms of Section 24N, the main function of an EMP is to provide information on the proposed management, mitigation, protection, and remedial measures that will be undertaken to address the environmental impacts of the activities to be undertaken. Although the EMP would identify the activities to be undertaken in order to provide the context for the measures proposed, it is not the function of the EMP to determine the activities which the applicant is authorized to undertake. Now, in summary, what the court is saying is that an environmental authorization evaluates the significance of impacts and it identifies mitigation measures. Whereas the EMPR is more of an implementation tool for how to actually implement these mitigation measures. So that, does that answer your question?
Yeah,
Okay.
does.
So again, just to summarize, we do not believe that these two documents is the same. They don't have the same role. They don't have the same function. What we do support, however, is the very crucial qualification that's also included in Section 12, subsection 4, which says that application for environmental authorization in relation to activities ancillary. So this deeming provision will not apply if such authorization was not obtained, was refused, if there was a failure to obtain environmental authorization. And I think this was referred in the presentation just before me as to kind of try and prohibit so-called illegal activities to actually be deemed an authorization issue. So we definitely support this qualification criteria, but we don't support the principle that of converting an EMPR into an EA. Thank you.
Okay, thank you. Do we take comments or do we take all the comments after? Our program is such that after every presentation we must have comments, but I hope members were taking notes. We can discuss all of them at once because there are only 3. Is it agreed? Okay, let's invite then. And thank you very much for the presentation. We will ask questions later after taking the last presentation. Can we welcome the City of Ekurhuleni? Can I check whether Mr. Fenter is here from the Banking Association? Just arrived. Or just missed your slot. I'm joking. Yeah, you'll be the third to make a presentation. Okay, Mr. Green doesn't have a PowerPoint. He'll just speak to is it a memo or the notes that you submitted? But hopefully you're not going to read it word by word. You're going to summarize it, okay? Over to you, sir.
Thank you, Chair. Yeah, my name is Stuart Green. I'm with the City of Ekurhuleni in the Environment and Waste Department. I'm a senior manager in charge of legislative compliance, meaning that we obviously monitor and enforce compliance in the regulated community, as well as make sure the metro itself complies with environmental legislation. The City of Ekurhuleni is quite an industrialized municipality. We have a large number of industries, and we also have air quality issues in the municipality. We're part of the Highveld priority area. Air quality in some areas is quite poor. Our comments really are specifically on the National Environmental Management Air Quality Act, and I'll be very brief. We, as the licensing authority, we would like more, basically more power to enforce the legislation and to have more control over the licensing function. And specifically what we are asking for is the power to revoke or suspend an atmospheric emission license once it has been issued. As the Act currently stands, we can issue an atmospheric emission license for 5 years. We can review it and we can vary it. But the Act does not allow us to suspend or withdraw a license if it's necessary as a last resort. In contrast, other acts, such as the Waste Act, does have a provision that allows you to withdraw a license. Specifically, Section 56 of the Waste Act allows the licensing authority to revoke or suspend a waste management license. If you look at, similarly, Section 93B of the Biodiversity Act allows the licensing authority to withdraw a biodiversity permit. If you look at the Environmental Impact Assessment Regulations 2017, there's also provision in there to suspend or withdraw an environmental authorization. The Air Quality Act does not contain these provisions, and we believe that we would like to have that power because we believe it's a fundamental enforcement tool. And there is a specific case that we dealt with that made us request this particular amendment. We dealt with a case in 2016. It was a company, I won't mention the name, but they started a tire pyrolysis operation in Ekurhuleni. Now, tire pyrolysis is a process whereby waste tires are converted into diesel, into fuel. It's a highly noxious activity. And this particular company started this process. Well, they applied for a license, obviously, and they provided predictions, modeling predictions as to what the emissions would be. And that's how you grant a license. You can only go on the predicted emissions from the modeling exercise. Now, in this particular case, we had complaints from day one, literally from day one. As soon as they started their process, the neighboring companies started flooding us with complaints, and they were quite serious complaints. The neighboring companies, some of the workers had to be booked off work. Some even went to hospital. They couldn't work. The emissions from this particular factory, you know, it went into the offices of the neighboring businesses, and it really caused a problem. Now, the thing is, we had issued them with an atmospheric emission license, and we don't have the enforcement tools to enforce compliance. We don't have a grade 1 EMR, so we can't issue a 31L compliance notice. We can't use Section 28 of NEMA currently because it's not delegated to the local authority. The only enforcement tool available to us is the Environment Conservation Act Section 31A directive, which is not necessarily useful in an air quality related scenario. So all we could do was engage with correspondence with the company and try and convince them to comply with the conditions of their license. We had no other enforcement tool available to us. When the matter was referred to me as the enforcement manager, I decided that the time had come that we came to a point whereby we had to withdraw this license because we couldn't allow this company to continue. And we actually issued a letter to the company, a notice of intent to withdraw the atmospheric emission license. It then came to our attention that actually we couldn't do such a, we couldn't issue such a letter because there's this legal principle called functus officio. If you're not familiar with that concept, what it means is that when a government functionary has made a decision or discharged their responsibility, they cannot revisit that decision. They cannot overturn it. They cannot change that decision. It's functus officio. It has to go to a higher authority. Unless, of course, the law allows you, the particular statute allows you to change that decision. So we realized that we were functus officio. Once we had issued a license, there was no way that we could withdraw that license. The only way would be to go to court to overturn our own decision. And that's obviously time consuming and quite costly. So we approached the National Department of Environmental Affairs. We lodged a query under the EMI help desk, which is the help desk that they have for enforcement officials. And we laid out the scenario that we were faced with. And the response that we got is in Annexure 1 of my submission. And it confirmed that, yes, indeed, we are functus officio. We cannot withdraw a license once it's issued. And that the other acts, such as the Waste Act, do contain these provisions, but the Air Quality Act doesn't. We don't know the reason for that. And that the only enforcement tool available to us would be to go to court and get an interdict against that company, or go to court to overturn our own decision. So, based on that, we would like the Air Quality Act to be amended through the insertion of a clause. I've just proposed the clause 46A, which is basically verbatim from the Waste Act, and it just allows the licensing authority to revoke or suspend an atmospheric emission license where it becomes necessary, where there are serious non-compliances to the conditions of that license, where we've already engaged the company to try and bring them into compliance, they failed, and the only option available to us is to withdraw. And if you think of, under the Waste Act, there has actually been such a scenario. If you look at the Shongweni landfill sites in KZN, the Department of Environmental Affairs actually suspended their waste management license for a particular period because of their non-compliances. So we believe this is quite an effective tool. And even issuing a notice of intent to withdraw is enough to cause that company to come into compliance. You don't actually even have to withdraw a license or suspend it. You just have to put them on terms to say, you're on terms now, you've got 30 days to comply, or your license will be suspended. And you'll be amazed at what companies suddenly do when they realize that their license to operate is about to be suspended. And you know, this type of power is similar to other agencies. If you think of the Civil Aviation Authority, they have the power to suspend the operating licenses of aircraft. But when it comes to air quality, where you can't control the gases and they're having an immediate impact on human health, suddenly you can't suspend that license for a period of 5 years. So those are essentially our submissions. A clause 46A, if it can be considered. And obviously it will be a last resort, and it will be a decision that's made rationally and legally and in terms of PAJA. You know, it won't be an arbitrary power that is given to the licensing authority. It will be done in terms of the law. And of course the decision will be appealable. And if a company can also take us to court if they believe our decision to suspend their license would be unlawful. And Chair, I don't know who the chair is at the moment, but
There is a chairperson,
So-
there's
oh,
no
you- sorry.
confusion.
sorry, Chair. Those are those are submissions.
Mr. Green, you have made your case well led. I think it's great. We have heard you. Thanks a lot. You can just give space to Mr. Fenter so that he makes his presentation. We'll engage you later on if there are questions for you. Yes, don't go far. Okay. Press the, yes.
Good morning, Chair, Portfolio Committee members. Thank you very much for giving us the opportunity to present here today. There are basically two concerns that we have within NEMNA, which I will touch on in a minute. Just to say to you, who are we? We are the Industry Association for Commercial Banks. We have 33 member banks, both South African and international banks that have branches in South Africa. All commercial banks are registered with Banking Association. And what we try to do is we try to influence an environment in which banks can operate profitably in a way that promotes international best practice and sustainable socio-economic growth and development. The first area of concern that we have with NEMNA is Clause 8, and it pertains to Section 28.4. These are the two sections which I think you're all familiar with. But from our perspective, the parts of that sentence that read, and any other person to whom the duty of care applies, and proportionately from any other person who benefited from the measures undertaken under subsection 7, or we believe they don't adequately define what the role of a lender is as far as that matter is concerned, and who the responsible person is for the pollution or degradation of the environment. Similarly, Section 28.1 of NEMA does not adequately clarify the position either. What we did when regulations were promulgated in 2011 is we therefore went to the department and applied for exemption from Part 8 of the Waste Act. Unfortunately, our application was declined. When we made the application, we looked at it from a responsible lender sector perspective, and we actually broke our application up into two halves. The first was to deal with a retrospective perspective, where clearly as lenders we are not in a position to exercise any retrospective control, and we asked for a blanket exemption from retrospective liability. What we also did is, from a progressive perspective, we actually suggested that as a sector, lenders should be responsible, and therefore the department should consider imposing what is known as safe harbor lending arrangements that lenders would be required to comply with, and if they didn't, there would be a contingent liability that they would attract. In our motivation, and we have attached it as an annexure to you, there are basically 5 or 6 annexures. The one was where we did a whole lot of international research, and we looked at 10 countries and what their legislation says as far as lender liability is concerned. We looked at the South African position and the implications for South Africa, and I'll touch on it in my next slide. We, as a sector, what we did is we undertook a number of initiatives as the Trade Association for Commercial Banks. The first thing we did is we went to the Institute of Valuers, and they gave us the opportunity to present nationally to all registered valuers in the country to make them aware of contaminated land and what they should look for when they go out and value properties. Now, they're certainly not environmental experts, so it's really just what they can actually see on the ground. And what we actually did to support that was we created a contaminated field guide, which gave them a whole lot of pictures, which would help them to actually identify what they think could be contaminated land and report it back to the lender concerned, who would immediately get an environmental expert to go out and assess the site. What we also did is to make all frontline staff aware of land contamination is through our bank CETA. We designed an introductory training course. Our staff in the banks who deal with these matters on an ongoing basis actually go through international training, either through the United Nations or through the IFC, to actually be experts in social and environmental risk. And then as an industry, what we did is we created a document called Principles for Managing Social and Environmental Risk, which went to our board and was signed off by our board. And in it, we focus on 4 areas: own operations, products and services, investment and lending practice, where we would follow global best practice as well as local legislative frameworks as far as environmental and social risk is concerned. We also created guidelines for our members that their waste management that they incurred at the numerous branch outlets, what they should do about it. In our motivation to the department when we applied for exemption, we said, look, from a retrospective perspective, there are principles of equity and fairness potentially involved. Our constitution protects us on that. We're unable to price loans, our term loans, which is about 1.3 trillion rand. If you look at the addendum, that annexure which we enclosed, you're talking somewhere between that and the, it's probably around about 10 billion rand that it would cost the sector. And the way the sector would recover that money would be to claim it, to get it back in the form of higher interest rates from other product lines which may not be to have socio-economic benefits for our country. Outside of that, we would obviously have a liquidity squeeze if we had sizable books where land was contaminated and we had to downgrade the value of our security on which we placed reliance. And you know, South Africa has got is a resource-intensive country. At least 30% of the stock exchange is related to the resources. So of course, there are a whole lot of sectors and areas and companies listed on our stock exchange where there is potential for contamination. Now, what happened in America is it trudged along very nicely, where the lenders felt this level of uncertainty around what is their obligation. And then there was a court case which triggered a withdrawal or partial withdrawal from lending to high-risk sectors within the US. And the last section I deal with that, where we talk about 62.5% of loans were declined by lenders in high-risk sectors, and 45% of lenders actually withdrew from the sector. Now, in South Africa, we haven't had a claim against a lender because they granted a loan to a party which contaminated the land. We've only had 2 instances, one which was where one of our DFIs actually had an equity stake in a company, and because that company had gone into liquidation, they became responsible for remediating that land, which everybody is comfortable with, and I'll deal with that in a second. The second instance we've had is where lenders have actually repossessed properties only to find out that they are contaminated after the fact. Because they'd moved them into their name, they had to remediate it. So what are we trying to say? What we're trying to say is, if there is a situation where the department seeks to recover the money from a lender because of land contamination, and where they merely lent their money, it could have ramifications similar to what I explained happened in America. And of course, one of the things that we don't know is how much land is actually contaminated in South Africa, and I'll deal with that as our second part of our submission. In America, they created legislation called Safe Harbor, and what it did is it distinguished between participation in management, and what they meant by that was where you took an equity stake in a company, or you had a direct control over the operations or the management within that company. And there they said, you know, you are, along with all the other parties, potentially liable if land is contamination to actually pay for the remediation of that land, and that's fine. The second part of what they did is they created CERCLA, and what they did in CERCLA is they actually created a best practice in terms of the processes that lenders need to follow. Prior to granting a loan, during the loan period, during the step-in or takeover by the lender, and where a lender forecloses on a property. And if a lender adhered to those best practices, they would have what is known as safe harbor. And that's essentially what we are proposing here today, Chair. Our recommendations as far as the change in wording to this there are two parts within NEMA that we were suggesting needs to be changed, where it becomes a lot more specific as to who is actually has the duty of care, and then also who is the responsible person, and those are contained in our submission. The third recommendation that we're making here today is that we are of the view that the Waste Act should be amended as detailed in what I've been talking about safe harbor and so on. There's a second area within NEMLA where, and it also relates to the Waste Act that we are concerned with, and that's section 41.1, which is not addressed outside of the wording that you see before you. And the problems we have with it is, there are a number of problems. I think the first problem is the register is held outside of the deed registry. Now, the deed registry is the repository for all land and liens against that land in South Africa. We have a world-class deed registry. It's rated in the top 10 in the world. And to actually retain a register outside of that, where that information is not contained within the deed registry, actually dilutes our registry. We're suggesting that it should be in the registry. Outside of that, what our Department of Rural Development and Land Reform, who actually own the deed registry, they're busy with a strategic project at the moment. We've just had the opportunity to engage at NEDLAC on what is known as the Electronic Deed Registries Bill, and this is where they're going to convert the deed registry into an e-platform. All the paper will be removed, and it will create a bespoke system to interface with the numerous bodies that are required to be involved when you actually effect transfer of a property or a bond. So it will interface with SARS, Department of Home Affairs, etc., etc., etc. The second part of the problem relating to this register is it's unavailable to the public. If you want it, you have to go through PIO to actually try source information, and it's not really a solution because of the cost attached to that and the timelines in getting that information. It will affect the normal transfer of properties because of undue delays. In South Africa, there's over 1 million loans and almost 100,000 transfers that are affected on an annualized basis. As lenders, we would have to, in terms of the Banks Act, Regulation 225, we are required annually to go and review all properties that we hold as security for loans that we've given. So we would have to try obtain that information on almost 1 million properties every year, which is really not feasible. So what we're actually saying is it's not practical, it's not working. It also places us in contravention of the Banks Act. The Banks Act, banks are lenders are certainly very strictly regulated in South Africa. Commercial banks need to adhere to the Banks Act and regulations there too. In turn, our Banks Act is taken from a global regulatory framework called Basel, and because we could be overvaluing or overstating the value of properties because we don't know if they're contaminated or not, we're actually in contravention of the Banks Act, and we've actually had to go to the Reserve Bank and explain the position to them that there's a problem here, and they've suggested that we just keep looking to see if we can't get our legislation aligned to international best practice. The other part of the problem is it obviously prejudices consumers, where a purchaser of a property can acquire a property and not know whether that property is contaminated or not. The legal fraternity is adversely affected. Lenders and intermediaries alike are all adversely affected. The other problem with keeping a singular register like this off-site is that it becomes outdated and inaccurate. The content is not updated all the time. And a classic example is when you sell a property between A and B. The register would contain the information of A, but not necessarily B. Whereas if it was in the deeds registry, that information would accrue against the property, not the owner of the property. So it would always be updated by conveyancers when they affect transfer of a property. Our recommendations as far as this particular section is concerned is, first of all, this is very doable. Back in 2011, we went to the Law Society and the department, and we actually worked out a methodology where you could immediately capture all contaminated land in South Africa on the deed registry without changing anything. There is what they call a node system, which is almost a subservient register within the deed registry, where if you put the initial CL into it, immediately that anybody interrogates that property, they would know that it is a contaminated piece of land and a contaminated property. I think the second opportunity is, given what the deed registry is doing in terms of its e-cadastre project, where it's going to build that electronic interface between the various other departments that you need to engage with when you effect transfer of a property, there is that opportunity to create a bespoke link, an electronic bespoke link between the deed registry and the Department of Environmental Affairs, where it can go straight into the register, where if somebody is looking to get a whole lot of more information around the remediation plan on a particular property, they can get all that detail out of the bespoke register, but by accessing that through the deed registry and not having to go via the department. From our perspective, the banks have got a number of IT specialists, and if the department needed any guidance or assistance in helping them to try design a bespoke register like that, we would gladly be prepared to assist, Chair. Those are the two issues that we have, Chair. I don't know if anybody has got any questions for me.
Okay, thank you. Thanks for your presentation.
My pleasure, Chair.
Members, we have heard all the three presentations from the Western Cape government, from the bank, the Association of the Banks, and from Ekurhuleni, the city of Ekurhuleni. It's time for us to raise questions if we do have them. Of course, where we need the department to clarify certain things as well, we can as well pose questions to them, as well as the departments, if you feel like you need more information from the presentations today, you are welcome to do so. So let's have that engagement so that when we are on our own and have to finalize this, we are more informed by whatever inputs that came from both sides. May I open the floor for anyone to raise questions? Honorable Hadebe, Honorable Dr. Luyanga will follow.
Thank you, Acting Chair. I think for us as members...
Let me just clarify one part. We can direct these questions to any of them, not in a particular order. Yeah. Okay.
Thank you very much, Acting Chairperson. Actually, for us as members, would like to know, or for myself, Chair, Acting Chair, I would like to know from the department if it's possible to incorporate these amendments that the Western Cape as well as City of Ekurhuleni as well as the Banking Association would like to see on this NEMLA amendment, if it's possible, because we would be really interested in what role we can play in order to ensure that those amendments are effected. That would be my take on the issues, Acting Chair.
Dr. Luyanga.
Mine, Chair, is maybe to the department as well, and it relates to the role of local government in ensuring that there is monitoring and evaluation of waste at that level, because there is no waste at national level. You'll find it in a ward, you won't find them anywhere. And all such work has to be done at that level. So it is equally important also for the full participation of the banking community because of where they are also located. So the department maybe must also breathe on the feasibility of decentralizing or delegating some of their functions to local government, especially the metros, because of the existing capacity that might exist in metros. But now on local authorities in general, where municipalities don't have capacity, department must be able to engage further and to make sure that there is there is an important role, vital for those levels of governance to participate.
My take will be, firstly, that we usually give the department some time to go think about some of these issues and come back to us on the basis of all the submissions that were given to respond to saying how is their take. But perhaps for now, it may be to understand whether some of these presentations were presented before with the department or to the department. I know the association says that your application at some point was declined, and although I did not get really the rationale of that decline. But what the city of Ekurhuleni presented, Mr. Green, I thought it was a clear issue. We may want that response later, but the other two, I thought the department may need to get back, go through what their act is like, I mean the bill, and be able to come back to us and present their own case. And if we need more information, we could still interact with the institutions that have made their own presentation, and not necessarily, impromptu say, respond to this one, to that one, and give an impression that is not well thought out of, if we are in agreement with that, so that we don't necessarily pressurize the department to here and now raise an issue. But I wanted to understand what the bank was saying when you said your application was declined. What was the basis? I don't think there's enough information here. Yes.
Chair, at the time we simply got a one-page and it didn't give any reason why it had been declined. From our perspective, I think, as a responsible sector, we're actually saying, guys, we actually need to play a role, and Safe Harbour is that role, to make sure that we lend properly and that we do the necessary due diligence, which would have been advantageous to the department, because now you've got a sector who's also supporting them in terms of contaminated land. And then the second part of that, which is the register, we've never been able to get any explanation from the department as to why they couldn't just put the initials CL against properties to sit in our deed registry. And back in 2011 already, and it still sits there today, we're saying we will support the department where we can to help them to actually get it a proper bespoke register in place. We have the expertise. If I need to, I can go to my board and see if I can get money, if money is the issue, because this is so important to us as a banking sector. We're unable to quantify property which is our A-class security in respect of contamination. We don't know how many properties are contaminated. Every now and again it pops out, but we need to quantify it, and we need to be able to access that information on an ongoing basis, Chair, to improve our lending and protect our assets on our balance sheet.
Perhaps at some point they will clarify us on their own view. But on what particularly the Western Cape government has presented, were you ever in any engagement with them? Or do you have any questions to any of the presenters today? Some things that you wanted them to clarify you more?
Thank you, Chair. Chair, I think I'll just respond generically, and I think I'm in agreement with your proposal that where we need to do a more comprehensive response for the purposes of the committee, we will do that. Remember that our process is that this process here is to basically highlight the issues of concern, right? The ones that we can address here, we will address, but we'd prefer your approach rather, where we go back and discuss some of them, because as you correctly point out, some of the issues raised by the Western Cape we've already been discussing, and in their introductory slide, they've already indicated that we've addressed them at MINTEC and some of them at MINMAC and at the working groups as well. So they're in support of some of the proposals, they're not supportive of others, and they've also then made additional comment on what we're proposing to amend. So we have engaged with them from that perspective. And then I think that would answer Honorable Khadebe's question whether we can make these amendments. That's the purpose of this process, Honorable Khadebe. If there's anything additional that we or yourselves would want us to include in the bill, it's during this process that we actually distill those additional issues based on what the departments proposed, what the presenters here have proposed, and eventually what you as the decision makers would then allow us to put into that legislation. So yes, we can make the amendments. Then the other issue was around delegations and functions to the local authority, and specifically making capacity available. And Chair, you'd recall that we have presented previously in terms of our local authority, because I think one of the other members, I can't remember clearly who it was, also questioned the issue around local authority capacity development. And from that perspective, the departments indicated that we do that from a waste perspective, from an EMI perspective as well. We're making sure that we're having designation of EMIs at the local authority level. We also indicated the increase from the time that we've started to the present in terms of the numbers of designated EMIs, and also which provinces and the numbers in each provinces as well. So, Chair, just from the perspective of some of the issues that were raised here, we have interacted with some of the sectors in relation to addressing them, and we will give you a comprehensive response on each of the aspects raised in the presentation in our comments and response report. But I think maybe I should just allow Mr. Gordon to talk to the issue around the land registry and the engagement with the banking sector, because he'd have first-hand knowledge of that engagement.
Thank you, Sham. Good morning, everybody, and good morning, Acting Chair, honorable members. Relating to the presentation made by the banking sector, just to remind the House that Part 8 of the Waste Act deals with contaminated land and the remediation of contaminated land. We have been in engagement with Banking SA, and the clarity there I've just received from our lawyers now is that in terms of the original provisions of Part 8 of the Waste Act, Banking SA had applied to be exempted from all provisions of Part 8, and at that time the Minister had refused, because I think you were asking for exemption for all of your members as well. And I think the principle there, and we value the contributions you've made, and I think there's some useful aspects we'd want to engage with you further. There are some difficulties currently with the Deeds Act, and according to the current provisions of the Deeds Act, they do not allow for this register to be completely taken over in terms of the deeds registry. We are engaging with DLDR, and but the information is available as a register within the department as public information. And so we're in the process of transferring that onto the South African Waste Information Center website in terms of an additional system. But we don't have a problem with making that information public. So I think, Chair, we would value the engagement further on the exact provisions, especially in terms of the international best practice as well, and see how that can be incorporated further in the amendments. Thank you.
You will come in, ma'am. On the City of Ekurhulene's proposal, I thought it's straightforward and so on, but is there some response to that one? You want to respond to? Oh, okay, thanks. Is it not working?
Go to the next one.
That's fine. Thank you. If I press the right button, it will work. On the issue that the City of Ekurhuleni raised, it sounds very reasonable, but it was discussed at Working Group 2 of the MINTEC process, and the MINTEC members were not in favor of including that proposal in the bill. So the department requests permission that we go back and consult as exactly what the reasons were for not including it in the current bill, if you will allow us to do that. In terms of the banking sector, the Banking Association, I have a question. Section 40 links the contaminated land. Once it's contaminated, the minister has obligation to provide that information to the deeds office, to include in the deeds register. And also, once land is found to be contaminated, there's also obligation on the seller to, if he sell the land, to inform any potential buyer that the land is contaminated, and that is in terms of Section 40 of the Waste Act, and I wonder why that is not sufficient.
Okay, over to you. You can respond. Yeah.
Through you, Chair. I think as far as the first point is concerned, the deed registry is not capturing that information within it, despite us having engaged with them.
Speak to the mic. You may not be heard. You are being recorded anyway. Yeah.
I'm sorry, Chair. As far as the first point is concerned, when we engaged, we actually engaged with representatives from the deed registry, the Law Society, the department, and ourselves, and we were trying to seek a solution. And that coding that I spoke about in the note section, CL, would allow you to accurately know that that piece of land is contaminated. But the conversations never got to a position where there was any formal dialogue between Environmental Affairs and the deed registry to actually take that information and put it into the deed registry. So it just died despite our best efforts to try and get it in. As far as and we would welcome that engagement again, because I think it's a very easy task. If there are 5,000 contaminated properties in South Africa, you know, it would take somebody to capture that code onto those 5,000 properties, and it would be there forevermore until such time as they have been remediated, where the department would have to request the deed registry to actually remove that CL indicator off that property. As far as the second question is concerned, yes, there is an obligation on a seller to disclose that land is contaminated. It doesn't always happen though. It's either a position where the seller hides that fact, where they are aware that the property could be contaminated or is contaminated, and they don't draw to the purchaser's attention, which is what they call a patent omission. But it does happen on occasion, and it happens in particular within sectors like, for instance, commercial agriculture, where the pesticides and fertilizers have actually soaked into the underground water system and actually contaminated it. And that is very seldom disclosed. What we're trying to suggest, and yes, there are legal ramifications that the purchaser can take against the seller for not disclosing that, but you know, those become an after-the-fact situation. The other problem is, of course, the lawyer, the conveyancer who's acting for the buyer of that property is unable to check whether there's an indicator in the deed registry that highlights that it is contaminated, when they would be able to go to the purchaser and tell them about it. And then, of course, the intermediaries, be they an estate agent or whoever, is unable to, unless the seller tells them, is unable to identify that that land is contaminated. And then, of course, as lenders, we go along and we lend money over a 30-year period, only to find out after the fact that we've actually lent money against a property where the value has been inflated because what hasn't been subtracted from the market value is the cost of that remediation, which we would have, it doesn't mean we won't lend to that property, but we would actually make sure that that remediation actually did take place and that we would decrease the value of that security accordingly. I hope I've answered the two questions, Chair.
In fact, we'll still allow you further engagements. I think that's what all of you are calling for, just to find each other on some of the issues which might not have happened before today. So that will still happen. Yes, Advocate.
Okay, we'd like one more response as well. As I said earlier to the chair, that we brought all the relevant experts along just to assist in terms of their specific areas of work. So I'm going to ask Francis to just respond.
Thank you, Chair. I think it's more a question, just to try and also understand. It's more around your other issue, which was in relation to Section 28. And I think it'll help me to understand a little bit more by using a very real example, because I think and moving away from contaminated land, because I think that complicates it, maybe into a very practical example that we had within Knysna. So we had a particular landowner who went in and basically destroyed